Hi, welcome to Win Without Law School. I'm Arizona lawyer Julie Lebenz. Today, we are going to be talking about pursuing a temporary order in a post-decree or post-order modification case. So you're either divorced or you were never married, but you got child custody papers in place, and you want to make changes to those. You want to modify your orders. So you filed your petition to modify, and you want the court to enter some temporary orders in the meantime while your petition to modify is pending. So this is where you could file a request for temporary orders. You can also file a request for temporary orders at the time you file your petition. You don't have to wait. You could file it all at the same time that you initiate the case. Or if you're not ready or some issue arises thereafter, you could file after you filed your petition. So today we're going to talk about what is a temporary order. We're going to talk about the motion for temporary order, the proposed order, the order to appear, and some related documents. And we're going to talk about how that motion can be with or without notice. And we'll go through the differences between those two. We'll also go through the response to the motion for temporary order, the reply, and then also the next steps, which are the resolution management conference, the evidentiary hearing, if one is needed. All right, so what is a temporary order? A temporary order is an interim order issued by the court to address issues that need to be addressed while the case is pending, such as legal decision-making, parenting time, and child support. And then keep in mind, according to this statute, if there's a request for a temporary order for legal decision-making and parenting time, and there's no objection to that motion, then the court can award temporary legal decision-making and parenting time solely based on the pleadings. So you don't necessarily have to proceed to a hearing. It's just the court can order it if there's no objection solely based on the pleadings. All right, so here is the rule that applies to post-decree temporary orders for legal decision-making, parenting time, or child support. A party requesting temporary legal decision-making, parenting time, or child support must file a verified motion stating the legal and jurisdictional basis for the motion and the specific relief requested. The motion must include a proposed parenting plan containing the legal decision-making and parenting time requested for both parties. If the motion requests child support, the party requesting child support must comply with Rule 91.1. The motion must incorporate by reference the relevant allegations of the pending post-decree petition and not separately repeat them. So bottom line with Part A is you file a verified motion. We're going to go through the court form for that. The court form has the legal and jurisdictional basis in there. You'll indicate the specific relief you're requesting. And then there's a form for a proposed parenting plan, and I'm going to show you that form. So that's pretty easy to comply with. Regarding what you need for child support, that's going to be showing what child support is now and then showing what you want it to be changed to on a temporary basis. Timing, you can file the motion for temporary order at any time. You can file it when you file your post-decree petition or thereafter. And then the motion for temporary order needs to be served. And what happens is you receive an order to appear with a court date, and then you need to serve those documents on your co-parent. And we're going to talk about how to do that. Once you file your request for a temporary order, per this rule, the court is supposed to schedule a resolution management conference or an evidentiary hearing, whichever is most appropriate based on what's being asked from in the motion. Now, what temporary relief can you request in a motion for temporary order with notice? You can request to temporarily modify legal decision-making, parenting time, child support. You can also request to temporarily modify spousal maintenance. Now, I don't cover that in the forms here because it wasn't in the standard forms, but that is something else that could be requested. And I'll show you where it could be included in parts of the forms, but really There'll need to be more on that, but that is something that could be requested on a temporary basis, but it's not in the standard forms as far as I could see. Two options for a motion for temporary order. You can file with or without notice to the opposing party. The standard procedure is to seek a temporary order with notice. The option for without notice, it's also called ex parte, that is harder to qualify for because you have to show that irreparable harm will transpire if the court doesn't hear your motion without hearing from the other side. And you also have to explain why you couldn't give notice to the other side that you were requesting this emergency temporary relief. So the without notice is going to be when there's some sort of irreparable harm that could potentially unfold. So that's going to be rare, rarer. It doesn't happen all the time, but the with notice is going to be the most common. So we'll talk about both, but just keep in mind the with notice is going to be the most common. Also, what you're going to find is that if you pursue without notice, you're still going to have to do with notice, because the without notice produces a temporary order that's only good for 10 days, possibly longer if the court orders. But the bottom line is it's good for a brief period of time, and you're supposed to file a motion for a temporary order with notice in the meantime if you want it extended for longer. Now, what if you don't qualify for a motion without notice, but you still want to be heard? You still want your motion to be heard as soon as possible. Well, in that event, you can request expedited relief, and your caption needs to say expedited hearing requested. And then in your motion, you must specify facts necessitating an expedited hearing. Let's talk more about temporary orders without notice. When you file for a temporary order without notice, you're going to file a verified motion for temporary order without notice, a proposed form of temporary order, and they call it notice of hearing on the motion. The standard form is an order to appear. I'm going to show you all of those forms. The court may grant temporary orders without written or oral notice to an adverse party or that party's attorney only if the verified motion clearly shows by specific facts that if an order is not issued before the adverse party can be heard, the moving party or a minor child of the party will be irreparably injured, or irreparable injury, loss, or damage will result to property of the moving party, and that there's a written certification of the efforts the moving party engaged in to give notice to the other party of their request for this temporary order without notice, or explaining why giving notice should not be required. So there's a big burden to meet in order to qualify for a temporary order without notice. You're going to need to show the irreparable injury, as well as why notice should not be given or the efforts you made to give notice and why it wasn't effective. Continuing on with this rule about temporary orders without notice. The temporary order without notice, it expires at the date and time set for the hearing on the motion unless the court extends the time for good cause. And that hearing set on the motion, it's called the return hearing. It is supposed to be set not later than 10 days, that's going to be 10 business days, after the entry of the temporary order without notice, unless the court extends the time for good cause. So what we're looking at here is that the court is going to set a return hearing relatively quickly, and at that return hearing, your temporary order without notice will expire. When you get your temporary order and then the order with the date and time of the return hearing, you need to serve that as soon as possible. There's not going to be a bond required unless the court orders. So this is the procedure for a temporary order with notice. So we just talked about without notice, and I'm going to go to that procedure in the next slide, but I want to show the difference. So with a temporary order with notice, the first step is going to be to file the motion and the related documents, serve the motion and the related documents. At that point, your co-parent will have a chance to respond, then you'll get to do a reply, and then there's a resolution management conference, and then an evidentiary hearing if any contested issues remain. So that's the process with notice. Without notice, you file the motion. At that point, when you file the motion, the court decides if it's going to grant the temporary order without notice based on the pleadings alone, or if the judge wants to hear some testimony from you, so you can testify ex parte, and then the judge could decide whether or not to grant the temporary order without notice, or the court could deny it. Now, if the court grants it and the temporary order without notice is issued, then you need to serve it on the opposing party along with a copy of your motion, the temporary order that the court issued, and then also the order to appear that the court issues, so the order setting the return hearing. Then you prepare for the return hearing and you would conduct the return hearing. In between, within these steps, if you're wanting that temporary order without notice to continue beyond the return hearing, then you're going to need to follow the with notice procedure. You're going to need to also file a motion for temporary order with notice, file it, get a court date, serve it, go through this same process. All right, so let's look at these forms. Let's look at the motion for temporary order with notice, without notice, and the order to appear. First, we're going to look at a motion for post-decree temporary order with notice to modify legal decision-making and or parenting time. So this is the standard form in Maricopa County. Fill out your caption. It's going to look the same as the petition. And then indicate what you're requesting. So are you looking to temporarily modify legal decision-making and or parenting time? These are the two that are going to apply. Pick whichever one you're requesting. And then go through here. First is number one, the allegations of the petition to modify are incorporated into the temporary motion. Okay. Next is jurisdiction. So indicate what's true here, venue, answer that question. Indicate all the details about your underlying order that you're looking to modify. Provide information about your children that are subject to the order. And then here is where you're indicating what you want the court to do. Do you want the court to order temporary joint legal decision-making? Do you want sole legal decision-making? What's your reason for requesting to modify? And remember the standard under the law, we talked about this in the case strategy creation and also in the case initiation section, is that you need to show a substantial and continuing change in circumstances that justifies modifying the decree or underlying order. So that's would be a good thing to talk about here in your reason for modification. What are the substantial and continuing circumstances? Why do you need these changes at this point? Okay, temporary parenting time, same thing. Indicate what you're requesting and why you want to change parenting time. Temporary visitation, that's not going to apply. That's for grandparents and things like that. Any other orders you're requesting would go here, and then you're going to sign before a notary, and then you're ready to file this document with the court. However, with your motion, you're going to file the following additional documents. So you want to also include your temporary parenting plan proposal, and that's going to look like this. We've seen this form in a bunch of the other videos. It's a 10-page document, and this has all the details about legal decision-making and parenting time that you're asking the court to order. And then you've got your child support worksheet if you're requesting to temporarily modify child support. So if we go back here in the motion where it says other, anything else you'd like the court to know, you can add in here, I also want the court to modify child support. Here's the numbers. And then you would include your child support worksheet showing the amount you want it modified to. Now, if you're requesting to temporarily modify child support, or either party requests an award of legal fees and costs, then you also need to do the affidavit of financial information. Now, if you've already filed this in your case, you don't need to do it again unless your financial information has changed and you need to update it. So let's say you moved and your amount of rent is different. That could be a good reason to update your affidavit. What if you got a new job and your income's different? That would be a very good reason to update your affidavit. So if you've already filed this, you don't need to file it again, but you may want to file it again, or you probably should file it again if there's been changes to your finances since you last filed the document case. All right, so this is just page 1 just to show you what the document looks like, but I'm not going to go through the entire document on this video. I've done that in other videos. In addition, you've got your proposed order. So here's the temporary order. You're going to check the boxes for everything that you're requesting, and then go through this form and fill it out with exactly what you're wanting the court to do on a temporary basis for legal decision-making, parenting time, and/or child support. So fill this all in. You can, as you may have noticed, this form is also for divorce cases. So some of this stuff isn't going to apply, and you can just cross it out. Now, I wanted to show you the form for Yavapai County because I couldn't find a post-decree temporary order form for Maricopa County, but we do have one in Yavapai County. So here's the temporary order, and this is the post-decree order, and this is just for legal decision-making and parenting time. So this would be filled out, and then the judge would date and sign here, but you would pre-fill out these parts for the judge with what you're asking the court to do on a temporary basis. All right, next we've got the order to appear, plus in certain counties like Yavapai County, they also require a document called the petition for order to appear. So here's Maricopa County's order to appear for temporary orders. And just to go back on this document, you're going to fill out the top, you're going to fill out the caption, the case number, and this will be the name of the opposing party. And then the court will fill out the rest of this document. If you're in a county that requires you to also file this petition for order to appear, you will fill all of this in, date and sign, and then you'll also do, this is Yavapai County's order to appear form for post-decree matters. So you'd fill this out and fill out the name of your opposing party, and then the court would fill out the rest of this. All right, so you filed your papers, okay? You filed your motion, you filed your proposed parenting plan, your proposed child support worksheet, your proposed temporary order, and your proposed order to appear. The court issues your order to appear, and at that point, the court is supposed to schedule a resolution management conference. Keep in mind that at the resolution management conference, no evidence will be taken unless the parties agree. The purpose is to facilitate agreements between the parties to try to resolve this request for temporary orders and potentially enter temporary orders at the conclusion of the conference based on the parties' agreement. If at the end of the RMC issues remain that are disputed, then the court can set an evidentiary hearing, and the court must set the resolution management conference or the evidentiary hearing not later than 30 days after the motion is filed. The court cannot resolve disputed issues of fact at the resolution management conference without the parties' agreement. If the matter is going to be set for an evidentiary hearing, the court must set an evidentiary hearing on a date not later than 30 days after the resolution management conference. The court can extend the deadlines for good cause. And for any temporary parenting time ordered, the court is supposed to also determine child support. So I just wanted to bring that up, that the court is also supposed to address child support if temporary parenting time is entered. All right, so you filed your motion and associated papers. The court issued the order to appear and you got a copy of it. What happens next? You must act promptly to complete service. You must serve your co-parent with your motion for temporary orders with notice, your proposed parenting plan, your proposed child support worksheet, your completed affidavit of financial information, the issued order to appear, and your proposed temporary order. You need to include that. You have 5 days after receipt of the issued order to appear to complete service. Ultimately, you must complete service not later than 14 days before the hearing date. So right when you get these papers back from the court, you've got to jump on service. What are your service options? The first option is acceptance of service. This is where you meet with your co-parent and a notary or the court clerk. You hand your co-parent a copy of your motion, your proposed parenting plan, your proposed child support worksheet, your affidavit of financial information, your proposed temporary order, and the completed order to appear. Your co-parent signs the acceptance of service form before the notary or the clerk, and then service is complete when you file that signed acceptance of service with the court. Another option is certified restricted mail. This is where you mail a copy of your motion, parenting plan, child support worksheet, AFI, proposed order, and completed order to appear to your co-parent via certified restricted mail. Service is complete upon the filing of an affidavit of certified mail with the signed green card attached, or you can hire a process server either privately or through a police department or sheriff's office. And at that point, or for a process server, service is complete upon the filing of an affidavit of service. Now, given the short time frames involved here, if you're going to need good communication with your co-parent or with your co-parent, if they have a lawyer, you'll be able to get this accomplished in order to get acceptance of service done. So if your co-parent has a lawyer, you can send them the acceptance of service and they can send it back to you signed, and then they can file it. If your co-parent does not have a lawyer, but you have good communication with them, you can try to work out the acceptance of service. Alternatively, you could give them a heads up, hey, I mailed you these documents, you need to sign them. Otherwise, I'm going to have to hire a process server, and a stranger is going to come to your door at some unknown time and deliver papers to you, or a sheriff's deputy is going to come to your door. And a lot of people don't want a sheriff's deputy coming to their door, or they don't want a stranger process server coming. So sometimes you can get cooperation on the acceptance of service or the certified mail if you explain the alternative is the stranger or police officer coming to their door and delivering the papers. So these are your options to complete service, and you need to jump on this right when you get the completed order to appear from the court, and you need to complete service. Okay, let's look at the acceptance of service form. This is page 1. You fill out your caption, and then you're going to indicate what papers were served. What papers did you provide your co-parent with a copy of? There's additional pages to that document. The full document is in the video below, or is in a PDF below this video. Here is page 1 of the affidavit of service with signature confirmation. It's also known as the affidavit of service by certified mail. So this is the form you will use if you served your spouse via certified restricted mail. And that's a spouse, but it should say ex-spouse or co-parent. So here is the form. This is page 1. There's 4 pages. The full document is attached below. But you'll complete this, and on the final page, you're going to attach a copy of the signed green card and your receipt from the mailing. Now, if you hire a process server, and in particular, if you hire a sheriff's deputy to do this for you, if you hire the county sheriff or a police department, this is a form that can be used. This form does not get filed with the court. If you use a private process server, they'll probably have a form similar to this that they'll have you fill out, and this just helps them locate your co-parent so that they can serve them with the documents. All right, so let's just review this again, the procedure for temporary orders with notice. You file your motion. Once the court issues the order to appear with the court date, you serve the motion and the related documents on your co-parent. And then at that point, once the papers are served, your co-parent has a chance to do a response. On the other hand, we've got the procedure for temporary orders without notice. And in that event, you file your motion without notice and the associated documents. You potentially testify ex parte if the court wants testimony from you. The court's going to make a ruling. If the court issues the temporary order ex parte, you need to immediately serve the papers and the completed order to appear. You're prepared for the return hearing and conduct it, but your temporary order without notice is going to expire at the return hearing. So we're going to get into the pleadings for a temporary order without notice. So I just want to remind you that to qualify for the without notice option, you have to show irreparable injury and why you couldn't give notice to the other side. And keep in mind, a temporary order without notice is going to expire at the time set for the return hearing, unless it's extended for good cause. And the court is supposed to set the return hearing within 10 days of the issuance of the temporary order without notice. Okay. And then you've got to serve the papers as soon as possible. And there's no bond required unless the court orders it. So let's look at the motion for post-decree temporary order without notice for modification of legal decision-making, legal custody, and parenting time. You can also write in child support here. So fill this out, explain why you need the order. This is where you need to explain the irreparable injury. Let me correct this. You're not going to put child support here. The order is too short, but if there's something else you're requesting, you could put that there. But for the most part, because this is shorter, you're going to have just legal decision-making or parenting time. Indicate who's involved. Explain why notice was not given. And then also fill out this number 5 here, which explains about whether or not you're going to be filing a regular motion for a temporary order. Okay, so information about other emergency cases, if any other court cases involving the parties, any other government agencies involved, any crimes of either party, and then indicate your request to the court. So this is without notice. There's some sort of emergency. There's some threat of irreparable harm or injury. And so that's why you need an immediate order, and the court shouldn't have to hear from the other side because of this threat of harm. So this is a different type of order, and the standard to receive it is much higher. So along with your motion, you're going to have a proposed order. So here's what the proposed order looks like. And you're going to fill out everything you're requesting, and then the court ultimately will sign it if the court decides to issue the order. And then the final document to file for the motion without notice is the proposed order to appear. So you fill out the top and the name of the opposing party, and the court will fill out the rest of this document. If you're in some of the outlying counties, such as Yavapai County, you may also be required to file this petition for order to appear. So you'd fill it out, sign it, and then this is what Yavapai County's order to appear post-judgment form looks like. So you'd fill out the caption and put in the name of your opposing party, and the court will fill out the rest. And then just going back to this procedure, we're looking at the procedure without notice. So you file. If the court issues the order, then you need to serve it and prepare for the return hearing. And in the meantime, likely need to file a motion for temporary order with notice if you want the order to continue beyond the date of the return hearing. All right, so let's look at the next steps after filing a motion for temporary orders without notice. The court's going to review your motion and decide whether to take testimony from you, and ultimately whether or not to issue the order without notice. If the judge issues the order without notice, the judge must schedule a return hearing within 10 business days. That can be extended for good cause. Upon the judge issuing the order to appear for the return hearing, the party that filed the motion must serve the opposing party with the following papers: their motion, the temporary order, and the order to appear. If you want the temporary order without notice to extend beyond the date of the return hearing, then you're also going to need to file a motion for temporary order with notice by the deadline ordered by the court, if the court ordered a deadline, and then properly serve the papers. So for serving the papers, these are the papers you're going to serve: your temporary order without notice, plus the order to appear for the return hearing, plus your motion. Okay, let me back up. Step one is that the court issues the temporary order without notice and the order to appear for the return hearing, so it gives you a court date. You receive those documents from the court. You must act promptly to complete service, and you need to serve your co-parent with your motion without notice, the order without notice, and then the order to appear. And you must serve the papers as soon as possible or by the deadline set by the court. So we've got the same service options we talked about before, but really you're going to need to go with the process server most likely. I mean, if you've got an emergency relief, there's likely some sort of communication breakdown between you and your co-parent. So working with them to get an acceptance of service or a certified mailing done within these really short timeframes is likely completely unrealistic. So unless you've got communication with your co-parent or they have an attorney and you can get the acceptance of service done, then you're really looking at having to hire a process server. Okay, so that's the service, and then you proceed to the return hearing from there. Whereas, you know, if prior to the return hearing you file your motion for temporary order, you're going to file that, get a new order to appear, and then you're going to serve all those documents, and then there'll be a response and a reply and move forward with the RMC. So let's look at a response. What we have here is that the response is not required, but if you do file a response, then if there's child support at issue, then you need to complete a child support worksheet, and you're supposed to file your response not later than 3 days before the date set for the conference or hearing. All right, so let's look at a response. Now, I did not find a standard court form for a response. And so I made one for you guys. So here's the motion and here's the proposed response I made. So all the parts in this red color are what you're going to need to fill out. And this is for temporary modification with notice to modify legal decision-making and parenting time. So if the petitioner in the case filed the motion, then this would be the respondent. So you edit this to say respondent because you're doing the response. Alternatively, if it was the respondent that filed the motion, then this is going to say comes now petitioner. So you need to edit this so that it is correct for your case. Another way to put it is this is going to reflect whichever party you are if you're doing the response. So you're responding, and how this works is number one responds to each paragraph in the motion. So paragraph 1 in the motion says all allegations of the petition are incorporated into this temporary motion by this reference. So if you agree that, actually, let me back up. Sure, they're just incorporating what's in their petition to modify. So you can admit that. Another response could be this paragraph does not require a response because they're not making a firm allegation. So now we're on to page 2. So paragraph 2 is going to respond here. So read through what is in the motion, and if you agree with it, you would admit it. If you disagree with it, you would deny it. If you agree with part, you can say admit in part, deny in part, and explain what parts you agree with and what parts you don't agree with. For venue, paragraph 3, admit or deny. Information, or paragraph 4, review what they put about the underlying petition, see if you agree or not, so you can admit or deny. Paragraph 5, if they've indicated correct information about the children that are subject to the case, you can admit paragraph 5. And then I've got a paragraph 6 here. Anything not specifically admitted is denied, so that gives you a general denial, so leave that in. And then here, this will be whatever party you are. You're requesting the following relief. So here is where in the motioning party indicated what they're asking for: temporary legal decision making. So here you can say that whatever the opposing party is, pick them, that their request for legal decision making, do you want that to be granted or denied? If you want it to be denied, then explain what you want the court to do for temporary legal decision making. For temporary parenting time, indicate, this will be the opposing party. So edit this to name the opposing party, that their request for temporary parenting time be granted or denied. Pick whichever one you're requesting. If you're selecting denied, then explain your request. If you're selecting granted, you can delete the rest of this paragraph. Temporary visitation, the parties agree that this paragraph does not apply. That applies to third parties like grandparents. And then other, do you want the opposing party's request for additional relief to be granted or denied? And do you want any additional relief? You can explain that there. And then if we go down, this legal fees and costs is not in the standard form, but let's say there was a request in here for legal fees and costs, or in their document. You can render an opinion on that, or this is where you can make a request for legal fees and costs if you're looking to hire a lawyer. And then any other relief the court finds just in the circumstances. I declare under penalty of perjury that the foregoing is true and correct, and then fill out the bottom. Okay, so that's the response. Let's look at the reply. Again, there was no set form, so I made one for you guys. Here's the response, and the reply is going to be the same. The reply is going to be directly replying to what was in the response. So paragraph 1, if paragraph 1 was admitted in the response, then you could say something like, the parties agree that paragraph 1 is admitted. If paragraph 1 was denied and they explain why they were denying it, the reply is your opportunity to reply to whatever their position is in the denial. Same thing with all of these paragraphs. And then we've got the request for relief. Now, here's the response and here's the reply. So here is where you're just telling the court what you want the court to order. Do you want the court to order sole or joint temporary legal decision making? Do you want the court to award both parties joint temporary legal decision making, or one of the parties sole? Temporary parenting time, what are you asking the court to do? Do you want the court to order the petitioner or the respondent's requested parenting time? I would imagine it's going to be you want your request, so whichever party you are. Parties agree that temporary visitation doesn't apply, and then you can talk about additional relief if anybody asks for that, what you want to happen, anything you want to happen with legal fees and costs, and then that's it for the reply. Okay, then let's talk about the resolution management conference and the potential evidentiary hearing. So what happens is the court has to set a resolution management conference. The court can immediately set a evidentiary hearing if there's good cause for that, but in the majority of cases, the court's going to set a resolution management conference first. So the resolution management conference, there's some things that the parties are supposed to do before the conference, and one of them is a meet and confer. So at least 3 days before the conference, and in Yavapai County, they've changed that to 5 days. So look and see what your county is ordering in the order setting the resolution management conference. But the general rule under the law or under this, rule of procedure is 3 days to do a meet and confer. That's where you and the other side talk and try to resolve as many issues as possible related to the request for a temporary order. Also, each party is supposed to complete a resolution statement not later than 3 days before the date set for the resolution management conference. In Yavapai County, it's 5 days. So see what it is in your county. And then not later than 3 days before the date set for an evidentiary hearing, the parties must exchange exhibits. Now again, check your county. Yavapai is 5 days. Also, you've got to disclose your list of witnesses and the subject of their anticipated testimony and their contact information. If there is a current court order prohibiting contact between the parties due to domestic violence, then they don't need to do the meet and confer. Okay, attendance. Everybody has to attend the resolution management conference. So keep that in mind. Everybody must appear for that. Now, the resolution management conference is an opportunity to resolve disputed issues. That's the whole purpose of it, is to manage the resolution of the case. So at the resolution management conference, the judge is going to be seeing if the parties can agree to resolve temporary modification of legal decision-making or parenting time or child support. Is there any sort of agreement, and can they get that done at the resolution management conference? Often these resolution management conferences are held virtually now, either by video or phone, just because they don't take that long and there's so many of them that get set. So these often do happen by phone or video, but the agreements have likely been reached prior to that because the parties are supposed to exchange their proposed resolution statements and do a meet and confer. And so there's these opportunities for the parties to try to resolve things before the resolution management conference. And if they're able to, then they could come to the conference and put their agreement on the record. All right, now, if your case is not resolved, if all of the issues raised in the motion for temporary order are not resolved at the resolution management conference, then the court will set an evidentiary hearing. And most likely the court will set 30 minutes to 60 minutes for this hearing. So you're not going to have a lot of time for a hearing on a motion for temporary orders. Once you get the hearing date, calendar that, calendar any final disclosure deadlines related to the hearing, calendar your exhibit deadline, draft your list of witnesses and exhibits, complete your disclosure, and draft your hearing outline. You're going to do all that stuff to prepare for the evidentiary hearing. And regarding your hearing outline, remember this is going to be your outline. This is the procedure for the hearing. So you need to draft your opening statement. And then the party that filed the motion for temporary orders is going to call their first witness to the stand. So if you're the one that filed the motion for temporary orders, maybe you're your first witness. So you need to prepare your testimony for direct examination, which I suggest you make a list of bullet points of the things you want to testify about and bring that with you to the witness stand. So you have something to refresh your memory in case you forget about things you want to testify to. You'll be subject to cross-examination. Once cross-examination is over, you get a chance to do some final testimony on redirect if there's anything raised on cross that you want to clarify. If you are your first witness and you're done testifying, you can call your next witness to the stand. Now, given the short amount of time the court will give you, most likely for a temporary orders hearing, you may not have time to present 2 witnesses. But if you do present a second witness, then the witness would take the stand. You would need to ask them questions on direct examination. So in crafting your hearing outline, that's where you would draft your direct examination questions. Your second witness would be subject to cross-examination by the opposing party, and then final redirect if there's anything to clear up from what happened on cross. At that point, the opposing party gets to present their case, same procedure. They present their first witness, direct examination, cross-examination, redirect. Now, if you're the party that filed the motion, that means you need to prepare cross-examination questions for the opposing party's first witness. And then if there's time and if the opposing party calls a second witness, you would need cross-examination questions for that witness. And then there's the potential to present rebuttal witnesses, but there's probably not time. And then potential closing arguments if there's time. Now, if you didn't file the motion, you filed a response to the motion, then for your hearing outline, you're going to draft your opening statement. You're going to draft cross-examination questions for the other side's witnesses. And then you're going to have direct examination questions for your witnesses, and then your closing argument. Let's look at the law. So temporary legal decision-making, we're looking at what's in the best interest of the minor children. Same thing for parenting time. And then for child support, what is the child support obligation according to the Arizona's child support guidelines and calculator? All right, we have reached the end here. So let's look at our summary. What is a temporary order? It's an interim order. It's an order issued on a temporary basis to address issues that need to be addressed until a final order can be entered. You can request to modify on a temporary basis legal decision-making, parenting time, and child support. A temporary order can be issued with or without notice to the opposing party. To qualify for a temporary order without notice, you must show irreparable harm and why notice should not be given to your co-parent. If a temporary order is issued without notice, then a return hearing is set 10 business days after the order is issued. It could be longer than that for good cause, but it's going to be quick. It's going to be set as soon as possible, even if it's extended for good cause. And the order expires at the return hearing. So you'll need to file a motion for temporary order with notice if you want the order without notice to continue beyond the 10 days. Okay, so papers to draft and file. If you've got a motion with notice, you're going to file your motion, your proposed parenting plan, your proposed child support worksheet. If you're requesting to temporarily modify child support, your affidavit of financial information. If you're requesting to temporarily modify child support, or if you're asking for an award of legal fees, and then an order to appear, plus your proposed temporary order with notice. If you are filing without notice, you have your motion, your order to appear, and your proposed temporary order without notice. Now, if you're going the with notice route, after your motion is filed, the court will issue the order to appear. You'll receive it. You need to serve the order to appear and all the documents you filed with the motion for temporary order on your co-parent. They then have the option to do a response. If they do a response, you have the option of doing a reply. The matter will proceed to the resolution management conference. And if there's any remaining issues in dispute after the resolution management conference, then the matter will proceed to a contested hearing, also known as an evidentiary hearing. If you are pursuing a temporary order without notice, then the court will issue the temporary order without notice and the order to appear for the return hearing. You need to serve the papers. A process server is likely your best option, and prepare for the return hearing. The only exception to the process server is if your co-parent is represented by counsel. And if that's the case, then you can reach out to their lawyer to do the acceptance of service form. In the meantime, you need to draft and file a motion for temporary order with notice if you're wanting the temporary order without notice to extend beyond the return hearing. And then participate in the return hearing. And if you filed your motion for temporary orders with notice, there's the opportunity for the response and the reply, and then the RMC and the evidentiary hearing if anything is left in dispute. Remember that if you're doing a response, which is optional, then you'll also want to indicate what's your proposed temporary parenting plan, what's your proposed temporary child support, and then provide your affidavit of financial information. With the reply, you don't necessarily need to include any additional documents. Those would have been with your motion, so it'll just be your reply. And then with the resolution management conference, calendar the date of the resolution management conference, calendar 3 to 5 business days prior to the RMC, as that being a date you need to meet the RMC deadlines. Whether it's 3 or 5 days, look at your order and see what was ordered. The order setting the RMC should have that information. Email or mail your disclosure statement to your co-parent at least 3 to 5 business days prior to the RMC. File a proposed resolution statement, complete the meet and confer call, and then participate in the RMC. If there's still issues that haven't been resolved, the court will set an evidentiary hearing. So you're going to calendar the hearing date, calendar your disclosure deadline, calendar the exhibit deadline, draft your list of witnesses and exhibits, complete your disclosure, draft your hearing outline. All right, that brings us to the end of today's video. Thank you so much. And bring any and all questions you have to the live Q&A.